Hi, everyone. This is Kirk Schroder, and I want to welcome you to another edition of Brief Encounters, the Entertainment Law Edition. And I'm pleased today to have as our guest Joe Meadows, who is a partner and attorney at Gordon Reese. He's based out of Alexandria. Gordon Reese, a prominent national law firm. Joe has been on the program before. He is an expert in intellectual property matters and defamation and all sorts of things. But like most people today, he's been keeping up with artificial intelligence and how AI actually impacts various areas of the law. And so today, we're going to talk about Joe's understanding, at least till date, because I suspect you're going to tell me that it's a moving football about First Amendment rights for AI speech. And just for our audience, Joe, first off, welcome. And thanks for coming back on here again. Tell us what AI speech is, much less First Amendment rights for AI speech.
Yeah, well, thanks for having me back, Kirk. I couldn't believe it was back in December 2021. We
I
did our
know.
first podcast together, and I appreciate you bringing me on back then. AI speech, it's speech by an artificial intelligence.
So, like, if AI, we've seen these examples where, like, AI could reproduce my voice or so much. Is that speech? How does the speech break down in AI?
Well, I got into this whole issue well before AI was kind of mainstream. I wrote an article in 2018 about the First Amendment rights of internet search speech. So, Google search programs or Bing search programs. And I wrote an article about that. And at the end of my article, I thought, well, depending on how the law goes with internet search engine speech, may implicate in the future someday, what are we going to do with AI speech, where it's not a search engine that is quote unquote speaking, but it's an AI entity of some sort that is speaking? And how are we going to deal with those issues? Well, I mean, fast forward to 2023, 2024, and we are right smack in the middle of all the implications, legal and otherwise, dealing with AI. And so the same issues that I kind of anticipated way back when are at the forefront, certainly in the legal community.
Now, some of the search engine cases, those were litigated. Are those the NetChoice cases?
So the search engine cases go back a little bit, but they really start from the Supreme Court case dealing with Miami Herald, where the Supreme Court said Florida's right of reply statute violated the First Amendment, and you can't make a newspaper print something of a political candidate that you didn't want to include to begin with. So, sort of compelled speech. And from that decision, you've had some courts take that to the next level and say, well, if you're dealing with internet search speech and the First Amendment protected editorial discretion, is the search engine actually speaking if it's just some sort of electronic computer? Or how do you break that down? And courts have said, before you get to the AI issues, courts have said, well, if the search engine is being run by algorithms, who's creating the algorithm? Well, it must be a human. And if a human is using judgment to create an algorithm or do coding, then sure, you should be able to give First Amendment rights to search engine speech. Now take it to the next level, AI speech. That is not exactly before the Supreme Court in the NetChoice cases, but it's not too far away from the ballpark. So however this Supreme Court decides the NetChoice cases that were argued in February, and I suspect a decision sometime in May or June, however the court comes down on that, very well could be relevant to, in the future, what are we going to do with AI technology and its generated speech?
Which could impact a lot of people depending on how you're using AI and what's going on. I guess to break down some points that you made, obviously to get a copyright, you have to have a human involved, right? Dogs and cats can't get a copyright. And so the court has said that, if you are part of programming whatever software algorithm, then that human input can qualify, assuming all other factors are met, for a copyright. Right now, as I understand it, Sarah Silverman, others have sued claiming infringement on AI because at this point, AI needs content to train on. And how have those cases gone about? It strikes me that AI seems to be winning, if that's the right figurative speech.
Yeah, great issues. And you probably deal with that a little bit more than I do. I usually come at this more from the free speech aspect because I handle
A lot of defamation and things
yeah,
like
I
that.
handle defamation cases, both plaintiff and defense. I wouldn't call myself a constitutional law expert of any sort. I'm more of a litigator, and that's how I got into these issues. And so when I think about AI speech in the First Amendment, I think about if somebody's using an AI program or has a business and uses AI to generate content, if they are faced with a defamation suit or if they're faced with some sort of government regulation about their activities, can they stand on the First Amendment and argue that they're protected in what they've done? Or are they using some sort of automated AI tool? And let's just take an extreme type of AI, general artificial intelligence, that really doesn't rely on humans much, if at all. In that instance, how can you give a fully autonomous machine constitutional rights? Some say that you can because the focus is on the speech itself and listeners' rights, human beings being able to listen to that speech, and we should protect their rights to listen to content. On the flip side, you've got people, more traditionalists, saying, well, but Constitution is for the rights and powers of human beings. We're not giving things, inanimate objects or machines, we're not giving them constitutional rights. That's kind of the balance. But if you think about, 10, 15, 20, 100 years from now, how are we going to be speaking? Can you differentiate between humans and machines? Maybe you do give some sort of hybrid humanoid machine entity some sort of what we perceive as human constitutional legal rights. I don't know the answer to those questions.
Yeah, well, so I mean, let's just talk about this practically. People now are using Chat GPT, right? I mean, it's generating speech for somebody, right? Because they're either copying, pasting it, putting it in social media, they're putting it in some sort of writing or some sort. How does that scenario, the issues that you're looking at from a First Amendment, where's the liability and then where's the defense? Where's the First Amendment defense come in those scenarios? Or are there other scenarios that we would want to be aware of?
You may be talking about, there are a couple cases out there where there have been some defamation or tortious interference tort cases against AI platforms, whether it's Chat GPT or something else. And, the plaintiff is arguing the output has defamed me or injured my reputation, injured my business, and I'm entitled to compensation. On the flip side, the defendant entity is arguing, well, I wasn't the one that was speaking. You put in the prompts, you generated the content. I didn't blast it out to anybody. I blasted it out to you, or I helped you create it. I'm not the speaker. And so I think some of those cases haven't reached to the point where you've had any definitive rulings to say which way those are going to go. But that's one scenario where these issues pop up. Now, in the NetChoice cases, they aren't really dealing with AI, they're dealing with algorithms. And even from NetChoice perspective, they're admitting that their content moderation is being generated by human created algorithms, not any AI algorithms. And they're saying that Florida and Texas laws, respectively, these are actually two cases that were kind of consolidated at the Supreme Court level for a decision. They're arguing that the laws infringe their editorial discretion and their rights to moderate content, and the laws require them to speak and say things that they don't want to say. And so the laws should be struck down. The governments, on the other hand, are saying, well, we're treating you no different than any common carrier, like cable TV or telephone, and we're only regulating your speech. We're not telling you what to say. And that's kind of the issues we're waiting to see how the Supreme Court is going to decide in a couple months.
Wow. And what's your sense after hearing the oral argument?
Well, from a conservative standpoint, And I don't mean that in a political manner, but just as lawyers
Conservative
sometimes,
jurisprudence, you mean?
yeah, as lawyers, we're always conservative, right? I don't expect an earth-shattering ruling. I expect something to come down that will be either narrow, where they'll decide it on a very narrow basis with not a lot of large implications for other scenarios or other laws or other platforms, or I expect them to perhaps even punt and say, we don't have a full record here, and we're going to remand it back to the Florida and Texas courts, respectively, and have them develop a more full record before we tackle these issues. Because you have to remember that the challengers of the laws in these cases made a facial challenge right from the get-go, as soon as these laws were enacted, saying it doesn't matter how you ever are going to apply these are
And
illegal under
what
the
your
First
facts
Amendment.
are, just as a matter of law, this is the deal.
That's right. And if I recall correctly, either in the briefing or at the oral argument at the Supreme Court level, there was some concern that the record wasn't yet developed, and maybe we should tackle these issues on an as applied basis, and maybe we need to have a better record. I think that is generally what most people believe, although there is a decent group that says that the Supreme Court will outlaw these laws and say that they violate the First Amendment. I didn't see a lot in my research of people saying, oh, these laws are going to stand. I think the government has the harder case to make these laws stand at the moment.
Yeah. So let me then get to the bigger question, because I think you kind of imply a bigger point, and that is that, right now the technology is way ahead of the law, in so many ways. So, you litigate defamation, you litigate First Amendment issues and things like that. What do you see the hurdles, or what do you see the challenges just with AI in general, from a First Amendment standpoint, from a defamation standpoint? It still strikes me, and I may be wrong, that if I go on ChatGPT, and I'm sure this has happened, and I get them to write something that could be defamatory about another individual, I'm still going to be liable for that. Because I copied and pasted and put it up somewhere in social media or wherever I published it. One, do you think that's still the case, or that will still be the case? And or two, where do you think AI is going to change the dynamics in your area of First Amendment and defamation and speech and things of that good sort?
Well, on the first scenario that you mentioned, again, there are a couple cases out there where this is still percolating through the courts, don't have any definitive rulings. Hard to say how that's going to shake out. I think to a large degree, AI is being used by many, including us as lawyers, as an internal tool. And the results of the AI, whether ChatGPT or some other program, the results haven't been massively published out there to the point where you're going to have a lot of maybe defamation or other types of lawsuits to test that in the courts.
Yeah, but I guess the implication is, if I could copy and paste something off of ChatGPT or some other AI program that inherently is defamatory, let's say it meets all the state tests or things like that, for me to avoid liability because it came out of AI would just be, that would be like running a train through state defamation laws. I can't imagine that courts would let that happen.
Yes, you're right. I mean, you've even had some law professor and well-known practitioners in this area have pointed out what you just mentioned and said that, for the AI defendant to push forward a First Amendment defense in the face of the scenario that you mentioned, that's kind of a stretch. And so even those people who are more traditionally on the side of First Amendment and free speech have argued that that defense is weaker in an AI scenario for sure. But the other scenario where this is going to come up is where companies use AI to generate speech or to generate and produce content. And if they face government regulation or private lawsuits and they try to shield themselves and say, look, I wasn't the one that said this or that, it was this AI program, that's a tough argument for them to make.
I know there are services out there that automatically generate social media marketing, and you sign up for a month or something like that on a monthly basis, and you give them some parameters, and then generative AI will every so often hook up on their social media and write something about their business or something like that. And I imagine a competitor or someone might say that's not true or that's whatever, and then you have those situations. So I think what you're saying, and correct me if I'm wrong, is these AI services that generate content in my world, as an entertainment lawyer, we call it content. In your world, you call it speech, and you'd like it to be free speech per the Constitution. That that content, that speech that's been generated, when it becomes a subject of legal controversy, what happens there?
I think it's a kind of a broader question in a way. I mean, if we are going to take a very strict rule of the constitutional rights of free speech and how they were first created and apply it to this new technology, it is going to make the new technology difficult to navigate itself in a business and content world. If we are going to embrace the technology or appreciate that this AI technology is here to stay and only going to get faster and become more mainstream, there might have to be some loosening of the constitutional and other laws out there to allow that technology to flourish. It's almost at a very high level. I mean, what kind of society are we going to live in, and what are we going to allow this technology to expand and make our lives better, or are we worried about that? And depending on the answer to those questions, kind of depends on how the law should be applied.
It's a real quagmire because, on one hand, if I pay some service to generate some content, some speech, as you refer it, on my social media to help my marketing and otherwise to just generate content, white papers that, and someone doesn't like it and it creates a lawsuit, obviously the question is, can I assert my right of free speech depending on what the nature of that content is? Yet on the other hand, I don't know how much you've played with Chat GPT. My law clerk a couple months ago, we were just asking it questions and it got more things wrong than I would have expected. It's one of those, you tell your law clerk, don't, not that he was, but don't go relying on, AI, double check everything, this and that. And we just went through this exercise, and I was really surprised at the errors that are being made.
Yeah, well, I bet, and I agree with you. I sometimes use it as a double check. I also sometimes use it to generate bedtime stories for my two young boys, which is kind of
Nice.
cool. But
Uh-huh.
I bet if you and I had this conversation a year from now, when we discuss, let's just call it error rate, we might be a little bit less concerned with the errors. If you and I had this conversation 5 years from now, I'm not even sure how much we're going to be talking about the errors. The advancements in the technology and where they're going to be years from now, it's hard for us to even imagine sitting here today in 2024.
Yeah. So I don't know that we got to the second question. What other scenarios might this present problems in your world of litigation?
Well, I mean, we've seen the cases of AI being used in briefs to cite cases that don't exist and courts sanctioning lawyers for that kind of thing. And
Is there any civil liability for that outside of the contempt and the sanctions?
well, I mean, I guess the client, if there's a client out there who is involved, they might have a suit against their lawyer.
Well, what raises the point, to the extent you use AI and it makes mistakes and someone's paying you for that service, you've got liability there.
Yeah, sure, sure. And I mean, there are a lot of issues in our world, in the legal world, just as there are a lot of issues with your clients in the entertainment world and protecting their intellectual property. But I still think fundamentally it comes down to there's nothing we can do about AI and its advancements. It's going to happen. It's probably a good thing that it is advancing. It's just how the law is going to evolve at the same time that the AI evolves. And maybe it is that we have to balance out the creative rights of some people with the creative rights of other people, depending on, are they somebody who uses and relies on AI, or are they a pure human person, and balancing out those rights. I can imagine that there's some people out there who only want to hear the original human singer of some song, but there are other people out there who maybe prefer the AI version of that song. And one is probably more expensive than the other. These things are fluid, and the law has to evolve with the technology.
Well, states are already addressing that, Tennessee being the big one with the Elvis Act. I don't know if you're familiar with the Elvis Act, but within the last couple months, the state of Tennessee updated their right of privacy, right of publicity law to prevent AI generated voice. Tennessee, as you know, their right of privacy, right of publicity is all designed around protecting the Elvis. Like in Virginia, 8.01-40 expires after 20 years after the death of the party. In Tennessee, it's in perpetuity. Now, the Elvis Act, which is the new act, says you can't use AI to generate and mimic a singer's voice. And it's, I think, the first state. And I haven't had a chance to look at it, but I don't know how much more protection it gives than what other states already provide. Virginia doesn't cover voice in its statute. So technically, you could mimic someone's voice in Virginia. And correct me if I'm wrong, I think in California, Bette Midler was part of a lawsuit for voice and was successful.
Well, all these states have different nuances to them. California, New York, Virginia, Tennessee, and I guess at some point, it suggests that there may be a need for a federal law to come in here and provide some uniform rules.
So now, just setting the stage for what we've been talking about, I go down to Memphis and I regenerate Elvis's voice, which now is covered under the Elvis Act. And the Elvis estate comes after me for violating that state statute because I used AI to mimic. Do I have a First Amendment claim there? Or does any of this apply at the state level at these AI now, right of publicity, right of privacy, statutory protections that states are trying to implement?
Well, it sounds like it was an illegal copying, so I don't know that you could stand on a First Amendment defense there.
Okay, but if I'm not using Elvis's voice, because right now I think Google is still litigating, there's still litigation on whether just getting information off of Google to train AI is an infringement. So that question is still not resolved.
Yeah, the OpenAI New York Times litigation. Fascinating issues.
So in theory, the Supreme Court could say, the fact that AI was trained on Google and New York Times website, all the facts and things is not an infringement. Doesn't that then, if that doesn't take the copying out of the way?
Well, are you arguing a fair use issue here?
No, I'm just going to put out a song that mimics Elvis's voice. But I haven't done anything. I didn't take any from any albums or anything like that. I was just being lawyers arguing here, but I didn't use any songs or anything like that. Not even any sheet music or anything. I just asked ChatGPT to just come up with something for me.
Just for your personal use? You're not trying to commercialize it in any way?
I might put it out on my website or something like that.
Well, yeah, now you're getting into a little dangerous.
But I didn't do it, and it wasn't generated by me. It was generated by...
That's right. It's sort of like that. I mean, you're trying to put distance between what action you've done and rights of others by saying it wasn't me, it was this machine. And I think that's a hard argument to make. But at the same time, there are cases where you could apply that to today's AI technology and say, well, I think at some point we may be giving these AI machines some equivalent human type rights, which is kind of scary on the one hand, but at the same time, maybe that's where we need to go if we as a world and society are going to advance and embrace a technology that is supposed to make things better for this world.
Yeah. And that's really the core of what I was expecting you to say, is that it's going to get a lot more complicated. And ultimately, we may end up with litigation that goes before the high courts, trying to determine if AI has any, in itself, has any protections, legal protections inherent in AI and the technology as humans and people do. And that's pretty
Yeah.
scary, pretty freaky.
It is. It is. That's kind of the sci-fi aspect of this that has interested me in the subject, and I'll be looking forward to how the Supreme Court comes down in these NetChoice cases in a couple months.
I was just going to ask you a couple months. You think by the end of the summer, or
Yeah.
we may want an update. So, just in our closing few minutes, what other thoughts do you have on the topic, or anything else that you think would be useful for our audience of lawyers and other listeners?
Well, it's not directly at issue in the NetChoice cases, but it's not too far away. The issue of Section 230 of the Communications Decency Act and how that protects social medias from defamation and other liability for the speech of users. How the Supreme Court decides the NetChoice cases may give an indication of their view of how far Section 230 should continue to protect social media companies. Some of the justices on the Supreme Court have been a little bit skeptical of the strength of Section 230 and have, in a way, signaled that, hey, social media, you want to argue that these laws are illegal and violate your First Amendment rights because all you are doing are content moderation. But at the same time, you're trying to push forward your editorial discretion to speech. And maybe we should change the 230 protection for you if you're going to keep advancing the editorial discretion argument.
We don't have the answers today, but we certainly know the questions, right? Which I guess is the case these days with AI. This has just been incredibly helpful. Any ultimate last words on any advice for lawyers that are doing any work in this area?
I think, lawyers in this area, whether you're studying the First Amendment issues or not, you need to be aware of the AI tools that are out there and know a little bit of how AI may impact your practice or may impact the business of your clients. It is here to stay. We've got to live with it and learn it and understand it. This is not like some technology that is a flash in the pan and was important for a while and then no longer is anybody talking about it. AI's here. Know a little bit about it, read up on it, do some Google searching on it, use an AI tool to put in some prompts just to understand it, and maybe pick up a book like I did, which kind of spurred me to do this latest article that I put out on it and was published by Law 360.
Awesome. Well, check it out on Law 360. Joe Meadows, partner at Gordon Reese, always grateful when you come on the show, and obviously for your expertise in these First Amendment cases, defamation, right of privacy, right of publicity. Joe is based in Gordon Reese's Alexandria office. And so just thank you for joining us.
Thanks for having me on, Kirk. Always a pleasure.
So thank you, our audience. You've been listening to another edition of Brief Encounters, the entertainment law edition. Hope you enjoy this podcast and keep listening. Thank you.